not having a podcast last week. I was out of the country. Um, Today, we are starting another series, but this time we are talking about criminal consequences, the consequences of criminal conviction on immigration in the United States. So, the question is, what constitutes conviction for immigration purpose? You see, criminal activities can be problematic when we are talking about immigration consequences. However, criminal activities can be divided into two. Criminal activities a U.S. citizen involved in a criminal activity, what is the consequence versus a non-citizen who is convicted of the same offense. Of course, a lot of criminal defense attorneys, their primary duty or their primary responsibility. Are you sure that the light is okay? Okay. A lot of the criminal defense attorneys, they have a primary responsibility of ensuring that their clients do not go to jail. So many, in fact, 99% of criminal defense attorneys, their primary responsibility is to prevent their client from going to jail. And of course, they will do anything to ensure that their clients do not go to jail. When the clients are U.S. citizens, there's no problem. But when they do the same thing for non-citizens, it becomes problematic. Because little things that ordinarily will not affect a U.S. citizen will affect non-citizens. I mean, generally, a U.S. citizen can be placed on probation for years, 5 years probation. It doesn't affect anything. But when a non-citizen is placed on the same probation, it becomes inadmissibility ground, and somebody can be deported or removed from the United States because of that probation. So we see the impact of this lack of knowledge, especially on the part of non-citizens. And that is why we are discussing this topic today. What constitutes conviction for immigration purpose? That is the topic we are discussing today. Thank you. If you have questions relating to criminal activities, relating to conviction, whether somebody has been convicted, whether the conviction is going to impact immigration status of that person, or maybe you still have a pending case, a pending charges, and you are not sure, or maybe your criminal defense attorney is advising you to take a plea bargain. Your criminal defense attorney is advising you to plead guilty. Those are the things that can lead to deportation. Unfortunately, many criminal defense attorneys are not familiar with immigration law. And of course, they do the best to ensure that their clients do not end up in jail. Meanwhile, inadvertently create another problem for the same client, which is the immigration part. And that is why we are discussing this topic today. So, if you have any question relating to immigration and criminal activities, this is the best time to send it in. So again, the topic, can you please display the topic? What constitutes conviction for immigration purpose? That is the topic that we are discussing today. So if you have questions, send it in. Now, when we say what constitutes conviction for immigration purpose, Conviction simply means a form of guilt when a guilt has been adjudged that somebody has done something wrong. I'm not talking of conviction in the criminal court now. I'm talking of conviction for immigration purpose. For immigration purpose, for as long as there has been a form of adjudged guilt, that is, the court has determined that somebody has done something wrong for immigration purpose. In fact, in some cases, even where the court has not convicted, it may still have consequence on immigration, especially when it relates to Adam Walsh Act. For immigration, the law allowed the adjudicator to go beyond what happened at the criminal court. In other words, plea bargain sometimes does not prevent somebody from being removed, because immigration is going to look at the totality of the offense. Especially when it's a drug offense, it becomes more problematic when it's a drug offense. When we are talking about conviction, when somebody is placed on deferred adjudication, pre-trial diversion, maybe fined, all these things constitute conviction for immigration purpose. Even if no jail term was involved, it will still constitute conviction for immigration purpose. So it is very important to understand it, especially when you have a pending criminal case. But of course, if you have been convicted, well, I wish you good luck. But at the same time, there are some attorneys who specializes in post-conviction relief. If you have been convicted and you realize that this may have an impact, especially with the impending new administration, their posture on criminal conviction is very, very, they have made it clear. The president-elect has made it very clear that anybody with conviction will be primary target. So that is why we are discussing this topic today, and it is important to understand it. In fact, I came in this morning and I wanted to ensure that we do not cancel this topic, because I wanted to ensure that people take advantage, because the new administration will come in January 20. We are still in December. So people still have maybe more than a month to do the needful if you found yourself in this situation. If you have questions relating to conviction and how it affects immigration consequences, this is the time to send in your questions. This is the time to send in your question. If there are questions that we have received, please start sending them in. Now, like I said, this is a series that we are starting today. Next week, by God's grace, we are going to be discussing aggravated felony. But today, I'm laying the foundation how conviction can affect immigration consequences and what constitutes conviction for immigration purposes, because there have been so many arguments on it. As far as immigration is concerned, even a pre-diversion plea, that for as long as there is a plea of guilt, if the defendant or if the applicant pleads guilty, it may have adverse effect on immigration consequences. However, where the applicant pleads not guilty and the case is dismissed, for immigration purpose, that is not a conviction. That is not a conviction. So it is one of the major distinctions is the plea, where an applicant plead guilty and then subsequently negotiated a plea deal. For immigration purpose, it will be a conviction. It doesn't matter what the deal is. Even if the deal is that the case will be dismissed subsequently, it will still be a conviction for immigration purpose. If somebody is fined, it will still be a conviction for immigration purpose. Whether there is a jail term or not, it will still be a conviction. So, as far as immigration is concerned, if the defendant plead not guilty and then the case is settled, maybe there's a plea bargain, yes, that will not be a conviction because of the not guilty plea. That will not be a conviction. But where the plea is guilty and then there is subsequent negotiation, it will still be a conviction for immigration purpose, irrespective of what the negotiation is. It will be a conviction for immigration purpose. So it is important, if you know that you did not commit the offense, the best thing is to plead not guilty. Under no circumstances should you plead guilty if you know you did not commit the offense, because for immigration purpose, the consequence will be great. It will affect you when it comes to immigration matters. But where the plea is not guilty, and then maybe the district attorney or the prosecutor realized that they cannot prove the case and all of that, and then they gave you a reduced charge. Yes, that will not, it is that reduced charge that will be considered by immigration. But if you plead guilty and they reduce the charge, it will still affect immigration consequence. So it is important to understand these little differences. And most importantly, if you are not a US citizen and you are arrested and charged for a criminal offense, I advise you to seek consultation with an immigration lawyer first before you plead to anything. Or advise your criminal defense attorney to also consult with an immigration attorney, so that at the end of the day, you are not solving one problem while creating another problem. It is better to solve all problems at the same time. But if you are a US citizen, it's a different ball game. You are only going to be affected by whatever happened at the criminal court. If the criminal court says no jail term, that's it. If the criminal court says probation, that's it. If the criminal court says your case is dismissed, that's it. If the criminal court says maybe you pay restitution and get the case dismissed, that's it. Whatever the criminal court says, that is the end of it as far as a US citizen is concerned. But as far as a non-citizen is concerned, whatever the criminal court says is not the end of the case. Because once you resolve the criminal case, you come back to face the immigration consequence of your actions. Now, there are levels of criminal conviction. We have a simple misdemeanor. Even for misdemeanor, we have different classes. We have class A misdemeanor, we have class B misdemeanor, we have class C misdemeanor, and we have felony, and we have aggravated felony. Like I said, we'll be discussing aggravated felony next week by God's grace. However, if your case falls within aggravated felony conviction, it does not matter your status. For as long as you are not a US citizen, it will affect your immigration status. Even if you have a 10-year green card, it will affect your immigration status. However, for citizen, it doesn't matter. So, but for misdemeanor offenses, yes, it will still affect your immigration consequence, but many of them are waivable, especially if it is class B or C. They are waivable. But when it comes to class A, it depends on the peculiar situation, circumstances of each case. And also, it depends on whether it is only one conviction or multiple convictions. So, I say that. Oh, okay. I thought questions were coming in. Oh, okay. Maybe because I saw your name. Okay. Oh, the first question, what is considered an aggravated felony? We are going to go into that next week. Please bear with me. I mean, I'm still feeling jet lag, so but I didn't want to cancel this topic, so that is why we are doing this. Now, what I will say regarding aggravated felony, we are going to discuss this extensively next week, but for this purpose, what I'm just going to say is that any offense that the punishment exceed 11, that the punishment is 12 months or more, is considered aggravated felony. Whether it is 12 months jail term or 12 months probation, it will still be aggravated felony. Secondly, if it is cash related, maybe somebody who defrauded another person or something, if the amount involved is 10,000 or more, it is considered aggravated felony. So that is where I'm going to limit it to today, because we are going to discuss aggravated felony as a topic next week by God's grace. The next question. What is a crime of moral turpitude? Well, crime of moral turpitude are crimes that the immigration authorities or the U.S. government believe that somebody who has committed this is a person that lacks good moral character. Generally, crimes of moral turpitude affect people who are applying for citizenship. They also affect people who are applying for waivers. They apply to people who are applying for green card. So if you see, there is a difference between somebody who has committed a serious, maybe, how do I explain this? Maybe violent crimes. Every violent crime is considered aggravated felony automatically. So every violent crime is a major disqualification for immigration purpose. However, even if the crime is non-violent, they still consider the morality behind the crime. So if you are convicted of a crime involving moral turpitude, generally people who are affected, maybe you have applied for cancellation of removal. Cancellation of removal requires that an applicant meet 3 conditions. An applicant must be living in the United States for at least 10 years, as at the time the notice to appear was issued. An applicant must have a U.S. citizen or permanent resident qualifying relative who will suffer hardship if this person were to be removed from the United States. And 3, the person must be a person of good moral character. This is where crime of moral turpitude comes in. For example, maybe you defrauded somebody. Although crime of moral turpitude is not a blanket thing, because it is on a case-by-case basis. In fact, crime of moral turpitude is one of the most litigated aspects of criminal activities in the United States immigration law. Because what constitutes crime of moral turpitude in one state or under a particular law may not be a crime of moral turpitude in another jurisdiction. For example, I remember I've defended somebody in the past at the immigration court where this person was convicted of obtaining money by fraudulent pretenses. In this particular case, this person was charged and convicted of theft. Now, for immigration purpose, of course, he served a time, or he was placed on probation and everything and served a time. He was a permanent resident at the time. So the immigration consequence, he was placed in removal proceedings and he was going to be removed from the United States. And my point in that case was that, look, this crime is not a crime of moral turpitude because this person obtained money by fraudulent pretenses. The money was handed over to him by the victim, even though the victim believed at the time he was handing over the money that he was doing legitimate business with this person. That is different from stealing, where you obtain money without the consent of the owner. But in this case, because the victim intentionally and willingly handed over the check in that particular case, I argued successfully that that was not theft. So, because he was charged with theft, it was difficult for immigration to prove that this person was convicted of a crime of moral turpitude, even though he was convicted of theft, but what he did was not theft in the sense of it, at least under the Texas law that he was charged with at the time. So at the end of the day, we were able to prove that this was not a crime of moral turpitude because the victim willingly handed over the check. Not that this person stole what is theft? When you obtain something that belongs to another person without that person's consent, with the intention of keeping it to yourself. Now, the difference here was that this check was obtained with this person's consent. Although he has been convicted at the criminal court, I was able to argue successfully that, look, this does not constitute moral turpitude crime for immigration purpose as the way the law intended it to be. So it's a complicated area of law, and sometimes we argued successfully and sometimes the court will disagree. But in this particular case, we argued it successfully. In fact, I can tell you that client is a U.S. citizen today, despite that, because I think if I recollect correctly, the amount involved was well over $10,000 at the time, which would have made it a crime of aggravated felony crime, because aggravated felony, once the amount is $10,000 and above, it becomes aggravated felony. So it is important to understand all these little things. You see, even this case, I'm not a criminal defense attorney, but I'm sure that if the criminal defense attorney has put up the same argument that I put up at the immigration, this person probably will not have been convicted of that crime. But again, it is also possible that the district attorney or the prosecutor could have amended the charges to charge him for something else, because even obtaining by fraudulent pretenses is also a crime. Although it may not be theft, but it's also a crime. So probably if they had argued it, it is possible they could have amended the charges and charged him with something completely different. So it is important to understand all these little things that create major problems for people. The next question Can I apply for US citizenship with a criminal record? Well, this is not a yes or no question because number one, we don't know what the criminal record is. As I've just explained, it is not every crime that prevents somebody from becoming a citizen. However, majority of the crimes can prevent somebody from becoming a citizen. In fact, there are things that will not even be considered a crime that can prevent somebody from becoming a citizen. For example, if you owe money to IRS, that may not be crime. That may not be a crime for as long as it is not tax evasion. Maybe the IRS audited you and realized that you owe some money and you enter into maybe payment plan agreement. That is not a crime, but it can still prevent you from becoming a US citizen. Maybe somebody is considered a drunkard. Although you may not be convicted of it, but if immigration sees a pattern that this person is a drunkard, it can prevent you from becoming a US citizen. So it depends on the level of crime. Again, it also depends on the timeline. You see, when you become a permanent resident, for the first 5 years, that is a period of, I don't want to say, like a trial period. Well, I don't want to use the word trial period because when it comes to citizenship, they look at the entirety of the period from the time you became a permanent resident. In fact, there are crimes that may not prevent you from getting a green card that can actually prevent you from getting citizenship. So, citizenship requirement is different from green card requirement, but the first 5 years of becoming a permanent resident is key. Is very key because there is a statutory limit. There is a period under the statute, that is the first 5 years, that you are not expected to be involved in a crime. That is a period that affects your citizenship more than the others. Others may still affect it too, but that first 5 years is key in the determination of your citizenship application. So this question, I really don't know what the crime is, so I cannot tell you specifically whether it can prevent you from becoming a US citizen or not. It depends on what exactly the crime is or the criminal record is. But generally, if the criminal record happened within the first 5 years of your green card, the likelihood that is going to affect you, I will tell you, is going to be about 90%. But if it is outside the first 5 years, then we look at, okay, what is the nature of the crime? What is the impact of the crime? And again, even if it is within the first 5 years, time is also something that affects the immigration decision. For example, minor crimes that have been convicted, that has been over 5 years, may have lower tendency in the consideration of your citizenship application. The next question: can a DUI affect my immigration status? Oh yes, because DUI can lead to aggravated felony. It depends on what happened. You see, I just stated it a few minutes ago that the requirement of citizenship is different from the requirement of green card. A DUI may not affect your green card application, but may affect citizenship, because this is one of the areas where issue of good moral character comes to play. They may waive it for you when it comes to green card, but they may not waive it when it comes to citizenship. But if you are charged and you pleaded not guilty and the case was dismissed, then it will not affect you. Because for as long as you are not convicted, that's why we are looking at what constitutes conviction. The fact that you are charged for a criminal offense and you went into trial and the case is dismissed, you are not convicted. That is not conviction. That is outright dismissal. So it's not going to have any effect on you. It's as if the crime was never committed. But all these things become problematic if you are convicted. If you go into plea bargain, if you plead guilty, that is when all these things become problematic. But for as long as you plead not guilty, it doesn't matter. Even if it is murder, if you plead not guilty and you are not convicted, there's no crime. So it doesn't affect anything. But when you plead guilty, yes, it does. So if you plead guilty to DUI, yes, it can affect your citizenship application depending on when the offense was committed and when you apply for citizenship. So if you are convicted within the first 5 years of your green card, definitely it will be an issue. But if it is outside the first 5 years, it may not affect it as much as it would if it is within the first 5 years. Again, even if it is within the first 5 years, if you allow time, a fluctuation of time, if you allow time to elapse, maybe you wait another 5 years and you ensure you don't get into trouble, you don't get into any additional DUI or any second offense, then the impact will diminish. The next question: are there any relief from deportation due to a conviction? Well, it depends on what the conviction is, and it also depends on your situation. Generally, if you have a qualifying relative, except it is unwaivable or you are in a position where it cannot be waived, which is another thing that can happen. Let me give you an example. There's a difference between somebody who entered the United States as a permanent resident and somebody who entered the United States on a visiting visa and then changed status from visitor to permanent resident. There's a difference when it comes to criminal activities. Incidentally, one will expect that the one who came in with an immigrant visa, the one who came in with a green card, will have the advantage. But no, reverse is the case. If you enter the United States as a permanent resident, if you enter the United States with an immigrant visa, if you are convicted of aggravated felony, you cannot apply for a waiver in the United States. Even if you have a U.S. citizen wife or husband, even if you have a U.S. citizen qualifying relative, you cannot apply for a waiver in the United States. There is no waiver that can save you from deportation. There is none. On the other hand, if you enter the United States as a visitor or with a non-immigrant visa and subsequently adjusted your status to that of a permanent resident, if you are convicted of aggravated felony, if you have a U.S. citizen qualifying relative, maybe as a spouse or parent, you have a U.S. citizen qualifying relative, you may be eligible for a waiver. But that same waiver is not applicable for somebody who entered the United States with an immigrant visa. So these things, it doesn't make sense, but I don't know why Congress decided to do it like that. But that is the reality. So that is the reality in this case. The next question: should I consult a criminal defense attorney or an immigration attorney for my case? If I decide to consult both, wouldn't it be best for both attorneys to communicate? Well, it depends on on what you are charged with. But irrespective of what you are charged with, if you are not yet a citizen and you are charged with an offense, if you know you didn't do it, just plead not guilty. But if your criminal defense attorney is advising you to plead guilty or to take any lesser offense and plead guilty, yes, you need to consult an immigration attorney. That is very important because a lot of criminal defense attorneys, they don't practice immigration law. They are not familiar with immigration law. They may agree to something that can actually put you in jeopardy. So it is very, very important that they consult with with an immigration attorney. And of course, they need to communicate. I mean, several times I have acted as expert witness in criminal cases where I was consulted by a criminal defense attorney to come and give an opinion in court on criminal cases as to what the impact of whatever conviction the court is going to give to that person, how that decision will impact the person's immigration status. So it's always good to consult with an immigration attorney if you are charged with any crime and you are not yet a U.S. citizen. It is very, very important. The next question: what level of conviction will make me permanently inadmissible? Well, that's a difficult question, but generally, aggravated felony makes somebody inadmissible. But as I've explained, in some limited situations, even aggravated felony may be waived in very, very limited situations. However, when we are talking about permanent inadmissibility, Adam Walsh Act is one example of permanent inadmissibility. There is no waiver. It is a permanent inadmissibility. Adam Walsh Act has to do with criminal activities involving children, sexual molestation of children, maybe child pornography, it's a long list, but basically sexual conduct against children. It's a permanent bar. It does not matter whether you are a U.S. citizen or not. That is one crime that goes beyond citizenship status. Even if you are a U.S. citizen and you are convicted of Adam Walsh Act, you cannot even petition for your wife if you are married. You cannot petition for your husband even if you are a U.S. citizen. You cannot petition for your children even if you are a U.S. citizen. So it's a permanent bar. You cannot petition for no one. And of course, if you are not a citizen, it's guaranteed that you'll be deported. Another crime that can be, another example of a criminal activity that can be permanent is what do you call terrorist related activities. That's another permanent one. If you are convicted of terrorist related activities, forget it. You better say bye-bye to the United States if you are not yet a citizen. Of course, if you are a citizen, you are a citizen. There's nothing. They cannot send you out of this place. Even if you committed this offense in other countries, you will still be deported back to the U.S. if you are a U.S. citizen. But if you are not yet a citizen, then you say bye-bye to the United States. The next question: I recently got a DWI and I have a VAWA pending. Will this affect my immigration application? It does not affect the VAWA because VAWA is a petition, it's not an application for green card. VAWA is a petition that says that you are a victim of violence from a United States citizen spouse or a permanent resident spouse. That is a petition. So criminal activities does not affect that. However, even if your VAWA is approved, you still have to meet the requirement of green card, which is requirement of permanent resident. Yes, criminal activities, including DWI, can affect that. But again, it depends on what you are charged with. Because, you see, the fact that you are charged with DWI is not a blanket conviction. Somebody can be charged with DWI and it can be a misdemeanor. Somebody can be charged with DWI, it can be a felony. Somebody can be charged with DWI and it can be aggravated felony. For example, maybe you are driving while under the influence and then you kill somebody. That's going to be a felony or aggravated felony. So the fact that you are charged with DWI by itself does not tell us what the level of conviction is going to be, because it still depends on what happened even while you are driving under the influence. Did you get into a wreck where people got injured? You could be charged with maybe manslaughter or even attempted manslaughter, even if the person didn't die. So again, the fact that it is just DWI does not tell us the grade or the level of the problem. So some DWIs may not constitute a problem, especially for VAWA victim. It may be waived because one of the advantages of VAWA is that you can a VAWA victim can serve as his or her own qualifying relative. For every other waiver, you need a U.S. citizen or a permanent resident qualifying relative. But for VAWA, they allow you to serve as your own qualifying relative. So if the DWI is within a misdemeanor range, yes, you may still scale through. But if it graduates into felony range, it becomes more problematic. The next question. Are deferred adjudications or plea bargains considered conviction under immigration law? Yes, they are conviction for immigration purpose. The only time that a deferred adjudication is not a conviction is if it is a pre-trial diversion. What that means is that, okay, you have not pleaded guilty, you have not entered a plea. The court has not determined that whether you are guilty or you are not. That determination has not been made. Now, maybe there is an understanding that, okay, you do certain things. Maybe you do community service, maybe you do certain things, and then the charges will be dismissed. But the moment you enter a plea simply means, are you guilty or not guilty? And you say, I am guilty. It doesn't matter whether the sentence is deferred. It will still have immigration consequence. But if you have not entered a plea and then the sentence is deferred and subsequently dismissed, then it is not a conviction for immigration purpose. or for any purpose at all. So that distinction is key in understanding what constitutes conviction for immigration purpose. The next question: how do suspended sentences or probation affect immigration cases? Well, again, the key here is where is your plea. Probation does not affect immigration. It doesn't matter whether it was pre-trial or post-trial. If you are placed on probation, it's still a conviction. In fact, if you are placed on probation of 12 months or more, it is actually aggravated felony for immigration purpose. So it's still a conviction, not only a conviction, but it will become aggravated felony if the probation is 12 months and above. It will be considered aggravated felony. So it's a conviction for immigration purpose. Suspended sentence may not be a conviction if there is no plea of guilty. But if there is a plea, if there is a guilty plea, it will be a conviction for immigration purpose. The next question: what questions should immigrants ask their attorneys if they are concerned about the immigration consequences of a criminal case? Well, what I'm going to say is, once you are charged with a criminal case, just take the charges and seek advice from an immigration lawyer, so that your immigration lawyer and your criminal defense attorney, they can discuss the case, so that if the criminal defense attorney is thinking of negotiating with the district attorney, he or she will have a clear understanding of what is acceptable and what is not. The next question: will my expungement clear my record for immigration purpose? No. That is actually a very, very, very good question. This is another area where a lot of people face problems when it comes to immigration consequences. Somebody has been convicted, maybe of a state crime. Along the line, this conviction has been expunged from the record, so that whenever they conduct background check, they don't see the convictions anymore. Let me tell you, ladies and gentlemen, for immigration purpose, there is nothing like expungement for immigration purpose. In theory, yes, the case may be expunged. In reality, when it comes to immigration purpose, there is nothing like expungement. You see, whenever you apply for any benefit under the immigration law, immigration uses the FBI to conduct background check. Whenever the FBI conducted their background check, they will see everything, including the convictions that have been expunged. They are going to see everything. And when they see it, immigration is going to ask questions. Oh, we see that you were convicted in 1982 of theft. We need police incident record. We need the charges, and we need the conviction record. Then you go to the court to go and apply for it. They tell you there is no record because it has been expunged. Now it's going to be problematic, because the fact that you are not able to get the record does not clear it as far as immigration is concerned. So the only thing you will need to do in such a situation is to get a document from the court confirming that this case has been expunged. But even at that, immigration will still invite you to ask you what actually happened. Because, like I said, they will still be able to see it despite the expungement. And of course, if it is a crime that have any immigration consequence, the consequence will still come upon you, irrespective of what happened. I remember I have a client recently who had a 1982 conviction. We could not get any record of this conviction. This person applied for citizenship and it was denied. We tried everything humanly possible. We could not get it. Actually, this person was pardoned by the state governor. It was a state offense. This person was pardoned. Remember, pardon has effect of clearing everything. That is one thing that survives immigration consequence. If somebody is pardoned, that is it. It was as if nothing happened. But in this particular case, immigration still requested to see what happened. And we were not able to get the record because every time we applied, there was no record. If I recollect correctly, I think we had to eventually engage a private investigator who was able to dig into some old documentations about this case, and then we were able to submit it to immigration to give them an idea of what actually transpired before they finally approved the petition. Because remember, this person has been pardoned, so there was really no offense. But you can't just tell immigration, oh, you have been pardoned, no offense. No, they still want to see what happened. So we had to provide that information before the case was eventually approved. And to God's glory, that client is a U.S. citizen today. So expungement is not enough when you are dealing with immigration. The next question: are there any waivers that forgive criminal offenses under immigration law? Oh yes, there are so many. There are so many waivers. I just finished talking about pardon. That is one. Even immigration themselves, they have a waiver of criminal grounds of inadmissibility. But of course, an applicant will have to meet the requirement. And one of the major requirements when it comes to waiver of criminal ground is to have a U.S. citizen or a permanent resident qualifying relative who will suffer extreme hardship if this person were to be removed from the United States. But of course, there are waivers. It also depends on what is the nature of the offense. Again, some waivers may be covered by 212H, that is criminal grounds of inadmissibility, Section 212H of the Immigration and Nationality Act. Those are waivers that grant waivers for criminal grounds of inadmissibility. If the person is also a permanent resident and the crime has to do with obtaining green card by fraud, the person may be eligible for 237A1H waiver. That is another one. But generally, for people who have U.S. citizen or permanent resident qualifying relative and the offense is waivable. It is not every offense that is waivable. I just explained about Adam Walsh Act. If the offense is waivable, yes, it may be waived. Waiver may cure it. And of course, if a waiver has been granted when this person applies for green card, when you apply for citizenship, it will no longer matter because once a waiver is granted, it's granted. For as long as there are no new offenses. Of course, if you get a waiver the first time and you commit a new offense, the waiver will be useless. The next question: If a person is convicted in a foreign country but claims the process wasn't fair, how does U.S. immigration law treat that conviction? Well, U.S. immigration law does not interfere with foreign law. If somebody is convicted under a foreign law, that conviction will be respected under the U.S. immigration law. They don't interfere with how other people conduct their criminal defense system or the criminal rule of law. The only thing is, if it's a political offense, yes, that may be given a consideration. If somebody is convicted of a crime based on politics, maybe somebody is detained by the president or the government of his or her own country, of course, on political ground, not on criminal ground, of course, that may even be a valid ground for asylum. So, of course, U.S. will take that into consideration. But if it is simple criminal offense, they will not interfere with how each country runs their own country. The next question: how can driving without a license impact an immigration visa or green card application? Just make sure that you don't get a sentence. If you are arrested for driving without a license, the probability is that you will be fined. Just pay the fine. But if you are fined and you ignore it, and then it leads to arrest and detention, that's when it becomes problematic. But if you are just given a citation for not having a driver license, just pay it. That is not what we are talking about here, because if you are given a citation and you pay it, that does not have any immigration consequence. But if you allow the citation to lead to arrest, now it creates another problem entirely. If it is mere citation, no problem. The next question: how about if I plead no contest to a felony charge that was finally reduced to misdemeanor, then dismissed after 1 year probation? Well, that will still be a conviction, because no contest is the same thing as guilty plea. It's the same thing. So when you plead no contest or noli contendere, it is the same thing as pleading guilty. So it will still have immigration consequence, even if it is dismissed after 1 year. As far as immigration is concerned, it will still be a conviction. The next question: if someone admits to facts in a case but no formal judgment is entered, can that still be considered a conviction? Well, like I said, once you plead guilty, if I understand this question correctly, admit means guilty. You plead guilty. Once you plead guilty, if you admit the content, yes, it will have immigration consequence. Once you admit the allegations, it will have immigration consequence. Even if there was no formal pronouncement by the court, immigration will still request for the details, and they will take it into consideration in determining whether to approve or deny your application. But of course, if there is no conviction, that will probably help you. But I guarantee you that immigration will probably not approve that application. Those are the kind of applications that will take years and years and years. It will remain pending because they want to see the end of that case. The next question: what happens if a conviction results from a plea agreement but the person maintains their innocence? You can't have it both ways. You can't enter into a plea agreement and claim to be innocent. You can't approbate and reprobate. The moment you agree to a plea agreement, you are admitting. That's it. That's the way immigration will see it. There is no other way. So if you are sure you didn't do it, you are innocent, just plead not guilty. That's the only way. So once you agree to a plea agreement, And I will tell you from experience, 99% of plea agreement comes with a guilty plea. Because if you don't admit your guilt, then there is not going to be any agreement. 99% of plea agreement will require you to admit to it, plead guilty to it. And that is why immigration pays attention to guilty plea. Because once you admit, you can't go to immigration court and say, oh, I was unjustifiably convicted. But you pleaded guilty, you admitted it. Something that has been admitted need not be proved. That is the law worldwide. So if you admit something, the government no longer have the burden to prove anything. You remember, criminal cases, the government has the burden to prove beyond reasonable doubt. But the moment you admit, there is nothing to prove. You have done their job for them. You have admitted it. They no longer have any burden. The burden has now shifted to you. So it doesn't matter whatever you do thereafter. You have already admitted that you committed this crime. The next question.
It's the same question, but he added a little more.
He texted as well.
Okay. How about if you plead no contest to a felony charge that was finally reduced to misdemeanor, then dismissed after 1 year probation? Does this prevent you from getting green card? You just answered this question, but didn't say how that may impact the pending green card application. Well, the reason I didn't say how that may impact the pending green card application is because I don't know the level of what was admitted to, what was the probation about, what was the charges. This is one of the reasons. Let me say this. Whenever it comes to criminal matters, immigration is going to request for 3 things. They are going to request for police incident report. Now, let me clarify it. Police incident report is not the same thing as police report. It's not. Police incident report, that is an internal document for the police department. You see, when you see the policemen on the street, whenever they make an arrest or whenever they do something, they have to report back internally to their office. Maybe somebody dialed 911. Maybe a police officer was driving on the street close to that place. Okay, the 911 dispatcher put it on the radio. Every police officer within that vicinity will hear the message on the radio. Now, maybe the officer decided to make a U-turn or turn from wherever the direction the officer was going to attend to that case. Now, everything that happened from the moment the officer turned to go to that place, whatever is going on, the officer has to write a report when the officer gets back to the station. That, okay, I was going this way, then this happened, then I had to do this and that. So that is what is called police incident report. Can you please help me bring it back? I don't know what I pushed incident. So that police incident report is different from police report. Police report is when you call the person who called 911. Yes, when you apply for, thank you. When you apply for police report, they will give you that police report. Yeah, you call 911 to say that somebody is assaulting you. That is police report. But when the dispatcher put it on the radio that, oh, there is an assault going on in so address, the officer who attended to that assault, when that officer comes back to the office is going to write a report. Okay, this is what I was doing. This is what happened when I got to that place. This is what I did. Maybe two of us got to the place, we separated the people. I was talking to A, my partner was talking to B. This is what A said, this is what B said, all those things. Those are internal documentation that the police officer is going to report when he or she gets back to the office. That is what is called police incident report. That is different from the person who dialed 911 and said that I'm being assaulted. Of course, that is the police report. So immigration does not use police report. They use police incident report because they believe, rightly so, that the police incident report will give them a detailed account of what actually happened versus a police report that is just going to say, oh, I'm being assaulted. So those are the major differences between police incident report and police report. So going back to the question, immigration is going to request for three things: police incident report, charges if any, and then the disposition. So what is the police incident report? What led to this thing? Were there any charges made? If yes, how did the case end? That is the disposition. So those are the three things that they are going to ask for. So this is why plea bargain does not matter to immigration, because when they look at the police incident report, it is the details of what happened initially. That is what they are going to see. By the time you get to plea bargain, which is the disposition, it is the police incident report that will give them the story of what actually happened. So it's not going to matter what the disposition is, and that is why except the disposition is not guilty. If you plead not guilty and then the case is dismissed, then the police incident report will not matter, because an accused person is presumed innocent until proven guilty. So that is the way that is. So talking about whether this prevents this person from having green card, again, that depends on what was the charges all about. If it is Adam Walsh Act offense, yes, it will prevent the person from getting a green card. If it is a waivable offense, maybe an offense waivable under INA 237 2128, if the person has a qualifying relative, then it will not prevent the person from getting green card. Or three, if it's a misdemeanor and the person maybe has a VAWA approval, then that person can serve as his or her own qualifying relative and still get it waived. So whether it prevents somebody from getting green card or not depends on the peculiar nature of each case. So that was why I didn't answer that question, but I hope this person has clarity. I believe that is the last question for now, or do I have any other one that I've not answered?
Oh no, they just sent more information.
Oh, okay, additional information. Okay. Why is it not showing up on my own phone?
No,
Okay, was sending it to the text. Okay. Okay.
I just didn't put it on there.
Okay. Case dismissed in 2020 before application for green card was submitted in November 2021. Police report and court document were attached. Case is pending until now. Well, if the case is dismissed, again, for as long as it was not dismissed based on plea bargain, if it was dismissed, then it doesn't have any impact. It's not going to impact the green card. Well, it depends on what the green card is based. If it's a family-based petition, it may not affect it. It may not affect it, but if it is not a family-based petition, it will go into what is in the police incident report. That will matter more than the dismissal. So I believe that should be the end of today's. We are far outside the 1 hour period, and I believe I don't have any question that is yet to answer. Anyway, if anyone have any additional question, just send it to us or hold on to it until next week. We are going to continue this topic next week, but we are going to discuss more about aggravated felony offenses. Aggravated felony offenses. What constitutes aggravated felony? You'll be shocked by the time I give you list of offenses that are considered minor, but as far as immigration is concerned, they are considered aggravated felony. So we'll discuss that next week. We hope to see you again next week. Until then,
It's marriage based.
yeah, so definitely since it is marriage based, the spouse will probably be a qualifying relative if immigration believes that waiver is required. So they should not have any problem with that. If immigration believes that a waiver is required, the U.S. citizen petitioner will serve as a qualifying relative. It's only become problematic if it is employment based, because employer cannot serve as a qualifying relative. That is when it is different. So I hope to see you again next week. Until then, please remember to invite your family, friends, colleagues at work so that you join us next week and you continue to encourage us. That is the only thing we are seeking. We are doing this pro bono. We are not charging any fee. We are not doing it for any pecuniary gain, but only to provide information to prevent people from making avoidable mistakes. Until next week, when we see you, God bless you. Bye.